Are you thinking about getting a divorce and you are unsure where and how to start? This video will guide you through the exact steps you need to take legally and practically. Hello guys, welcome back to my YouTube channel. I'm Solace Talks, a legal practitioner in Nigeria. Today I'll be sharing with us the practical steps in getting a successful divorce in Nigeria. So like I said in my previous video, if you want to end your union with your partner, you go to court. There's nothing like signing divorce papers to end a legal and statutory marriage. So there are three types of marriages in Nigeria. We have customary marriage, also known as traditional marriage, native law and custom. That kind of marriage where you share kola nuts is actually valid under our law in Nigeria. The second one is Islamic marriage, and the third one, the one that concerns us in this video, is statutory marriage under the act, the one you know as court marriage. So the law that governs divorce in Nigeria is the Matrimonial Causes Act. So this act recognizes a sole ground for dissolving a marriage in Nigeria, and the sole ground is that the marriage has broken down irretrievably. That is, the marriage is over and the differences cannot be managed. The marriage is over due to irreconcilable differences. So there are several facts the court will consider before the court can come to the conclusion that indeed this marriage has broken down irretrievably. So in my subsequent video, I will be explaining these facts in details. Also note that before you can go to court, before you can ask the court to dissolve your marriage, the marriage must be 2 years and above. That is, the marriage must have clocked 2 years. So if your marriage is not up to 2 years, you can't go to court, you can't petition, you can't, institute a divorce proceeding in court. There are exceptions to this general rule that your marriage must have clocked 2 years before you can, institute a divorce proceeding in court. So in my subsequent video, I'll also be explaining the exceptions to this general rule. So what are the steps to getting a divorce in Nigeria? The first step is to engage a lawyer. So you can decide to engage a family lawyer because a family lawyer is so vast in divorce cases. So he has handled plethora of divorce cases before, so he knows how best to handle your case. So that's not to say that you cannot engage any other lawyer that is not specialized in divorce matters. You can actually engage any other lawyer too. Well, you are expected to disclose all vital information, all details to the said lawyer. So in a divorce proceeding, you cannot represent yourself, whether or not you are the petitioner, whether or not you are the respondent. The petitioner is the party that instituted the divorce proceeding. So you are meant to engage a lawyer. It is the lawyer that will represent you, that will make your case before the court. So the second step is that the lawyer will draft the divorce petition using all the information supplied. So you are expected to disclose, to give all this information: your name, your date of birth, your current address, the respondent name, the respondent current address, the date of birth of the respondent, when you started cohabiting with the respondent, when cohabitation ceased, the date of marriage, the marriage certificate, and the marriage, whether or not there are children in the marriage, if there are children, the name, their age, and who is currently having the custody of the children, and how you want the court to make pronouncements on who takes custody, and also the maintenance, who will be responsible for the maintenance. All those information you have to supply it to the lawyer. So the lawyer, after getting all this information, the lawyer will draft it. The lawyer will draft the petition and serve on the respondent. Upon being served the divorce petition, so the respondent can decide to also respond. So in that instance, the respondent also will engage a lawyer. So the lawyer will now will draft and serve the answer to your own petition. So in a situation whereby you're unable to serve the respondent, so you get an order to serve through substituted means. So if you are serving through substituted means, you're asking the court that you either want to serve the person through WhatsApp, you don't know where the person lives, so there's no way you can serve. So you want to serve the person through WhatsApp, through email, or by pasting it. Either way, but before you can do that, you have to get an order from the court. The court must give you the go ahead to do that. The third step is that before hearing of the petition, the court would explore mediation between the parties. That's if the respondent answers the petition, or if there are children in the marriage, or they are jointly acquired properties, the court will ask the parties to do a compulsory meeting. It is known as compulsory conference. So in that compulsory conference that will be done between the parties and their lawyers, so they are meant to resolve some of the issues stated in the part. If they are able to resolve everything, it is all well and good. So if they are unable to resolve the issues, then the matter will proceed to hearing. So you have to also note that the fact that your petition is undefended, or the respondent is nonchalant about you getting a divorce, does not mean you still not enter the witness box to give evidence. You still have to enter the witness box and give evidence based on your facts stated in the petition. So you still have to give evidence. So in a situation whereby you are not in the country, or you are not within the jurisdiction, you can also give evidence virtually. You don't need to be in the jurisdiction, though you do that for a fee. You pay for the virtual hearing. So the first step is that the court will allow the lawyers to address the court on the accuracy of the fact before the court. However, the good thing now is that lawyers don't have to do oral address again. So what lawyers do now is that they file written address and they adopt same in the court. So after adoption of the written address, the court will adjourn to another day. So before the next day, the court must have analyzed all the facts presented before the court. So on the date adjourned to, if the court truly finds that the marriage between the petitioner and the respondent has truly, it has broken down, if the court finds that the marriage has broken down irretrievably, the court may order a decree nisi. So once the decree nisi has been ordered, you cannot get married until 90 days that the decree nisi will become absolute. And what's the rationale behind this? The fact that you can't get married until the nisi becomes absolute. The rationale is that the parties can actually reconcile. So if the party reconcile before the decree nisi becomes absolute, what they need to do is to come to the court and tell the court to do what? To revoke the decree nisi. So if you find this video educative enough, kindly like, comment and subscribe to this channel. Thank you very much.